Good afternoon, all. On behalf of IoT Academy, we welcome you all for the first session of national level faculty development program on IPR, entrepreneurship development, and startups. Let me introduce the resource person of today's session, Dr. S. Sunil. Dr. Sunil is currently working as an associate professor and head in mechanical engineering department and controller of examinations at Sri Venkateswara College of Engineering, Bengaluru. Dr. Sunil has 15 years of experience in teaching and 5 years of experience in research. His qualifications include BE from Sri Venkateswara College of Engineering, MTech from Siddhaganga Institute of Technology, and doctoral degree in mechanical engineering at Research Center Sri Venkateswara College of Engineering. His areas of interest includes renewable energy, biofuels, fuel additives, and optimization techniques. Dr. Sunil has published around 15 papers in international journals and conferences and has filed and published 5 IPRs. He has obtained 3 Best Paper and Poster awards, and the projects guided by him received the prestigious Chhatra Vishwakarma Award 2019 for the innovative idea under the theme Waste Management organized by AICTE. He has received grant KSCST, KSBDB, and other agencies, and has also reviewed articles for various reputed journals like Advances in Materials and Processing Technologies, Taylor and Francis, and Materials Today Proceedings LZ work. Welcome you, sir. And with this, we hand over the session to Dr. Sunil. Sir, please.
Thank you, madam. Thank you. Is the screen visible?
Yes, sir, it is visible, sir.
Okay. So thank you for the introduction, madam. Good afternoon, all. So currently I am working as associate professor and head of mechanical engineering and controller of examination. I am also innovation ambassador of MOE under the IPR section. Okay, I have filed and published 5 patents, out of which 1 has been granted, and the second one is in the grant stage. Okay. So today we will have some discussion on overview of IPR, that is the basics related to IPR, with a more amount of emphasis on patents. Okay. So what is intellectual property right? So before going ahead with different types of IPRs like patents, copyrights, trademarks, etc., what actually is this intellectual property? So it is a type of intangible property which you cannot touch and feel. Okay, it is your own property and is a creation of mind. It is related to the intelligence of a person. It includes invention, any literary or artistic works, symbols, names, aesthetic designs, and etc. So anything related to the invention, product development, we can file it as a patent. Any literary or artistic works under the copyright, symbols, names, etc. under trademark, and any aesthetic designs or industrial designs under the design category, we can file. Okay. So it is the product of person's intelligent, sometimes hard work as well as skill. Okay, so invention like logos, brand names, fashion design, music composition, song lyrics, etc. Many can be the examples of any IPR. Not only the products or inventions, so it may be sometimes some lyrics, songs, compositions, etc. So intellectual property rights are protection granted for the original inventor by the government, so that nobody else can copy it as it is. Okay, so IPRs are territorial in nature. That is, if you get an Indian patent, so it is protected in, only in India. Okay, so not outside our country. So it is all territorial in nature. Every country has its own IPR policies. If you want to get some rights in that particular country, we should be able to apply and we should prove that it is novel. What are different types of IPRs? So there are patents, trademarks, copyright, plant varieties, design, geographical indications, trade secrets, etc. So today we will discuss about 4 major. One is patent, the second copyright, third is trademark, and fourth is the design. So what is a patent? So any invention which can be converted to a product which is novel in nature is called, and which is useful to the society. So such product can be patented, and it should be applied before launching the product. So before bringing your idea into public domain, first you have to file your IP, then only you can bring it to the public domain. Once you announce it publicly, if it is available in the public domain, you will not be able to apply for a patent. The second is copyright. Any literary work or any artwork, any poetry you write, books, music, okay, or some process in technical, etc. They all can be applied in copyright. Even after publishing also, we can apply under our name if we have already published. So that can also be mentioned and we can apply for copyright. The third is the trademark. Okay. So it may be any symbol, a number, like we have seen Nike, Puma shoes, Toyota branded cars, etc. Like that, any symbol, brand name, etc. They can be put under the trademark category. Okay, it should be done before or sometimes after launching the product also it can be done. So any novel, ornamental or appearance of any product, okay, with a new design, okay, it can be under applied under design category, and this should be definitely applied before launching the product. So these are different types of IPR. We will stretch more on these four, which is more applicable to the R&D sector of engineering, right? So why should we register this IP? So what happens if we don't register? That we will discuss first. So there will be certain economic benefits. Definitely you have a wonderful idea. You will set up a plan, start converting it into a product, start selling in the market. Okay, if it becomes popular, obviously competitors will start copying your idea and they will bring in the product into the market. So it might affect you badly. So IP rights enable creators to protect and monetize their creations. That is your own idea. Whatever business we do out of our idea, so that monetary benefit should be obtained to us only. Okay, so third parties cannot use this creation without your permission. Okay, so this is one. We will have some economic benefits. Second is benefits to consumers and society. Okay, the piracy will not be there. So original inventor and original products will be available to the society from the original inventor. And also in certain sectors like R&D, okay, academic institutions, this promotes innovation culture, and also it increases the chances of R&D funding. More amount of patents you have, more amount of ideas you have, there are increased chances of getting R&D funding. And it establishes your ownership. 2 to 3 different products, okay, you have ideas converted into patents, then patent can be converted to product. So it will have some weightage in establishing your ownership, and there will be definitely legal benefits. If someone copies, okay, if there is some infringement, definitely under civil and criminal remedies can be obtained. If it is proved that your idea is copied by somebody and it is being converted to a product and sold, definitely we can question them. There will be some civil punishment as well as criminal remedies can be obtained. If you don't protect your IP, if you don't apply for IP, just start producing your own ideas into products, then anybody can copy it, anybody can become your competitor. So some effects of non-registration of a patent. So it is very difficult. You know that your idea has been copied by your neighbor. He is converting it into product and making money. You will not be able to do anything. Okay. And your idea may be applied for a patent by your neighbor or somebody, some ex. Okay. That also you will not be able to stop. Okay. So only remedies under civil law can be availed sometimes. Some infringement, if it is there, you have all the proofs with you that you are the original owner of that product. So to some extent, without patent, you can obtain some civil, under civil laws, you can obtain some benefits, but still you cannot claim your ownership completely. So these will be the effects. Now, one by one, we will take up in detail. As I told you, we will discuss more about patent today, and just introduction to design, trademark, and copyright. So what is a patent? Patent is an exclusive right given by a country to the owner of an invention. What do we mean by owner of an invention? You have some brilliant idea. Okay. So how do you get the ideas? Need of the society is the mother of all inventions. There is some problem in the society. You find the problem, try to solve it. Okay. Whatever in the process of solving, you take the steps, everything you document, it will be an invention. Okay. So you apply to the IP office, okay, state with all the relevant documents. Then once IP is granted to you, you can make use of it. You can manufacture goods out of it. You can market and you can make money, and you can solve the problem of society parallelly. Okay. So patent is an exclusive right given by a country to the owner of an invention to make use of it, manufacture the goods, market, and if the invention is satisfied. So it is granted by government for a novel invention, something new, which is not existing in the society for a limited period of time. So once you apply patent and if it is granted, from the date of application, it will have a validity of 20 years. After that, it will be open to public domain. Okay. So patent gives the inventor exclusive rights to the invention and prevents others from making products out of it, using or selling that idea. So why should we apply patent, and what is the status of our country with respect to patenting? So as per the Global Innovation Index, India is moving way at a way faster rate. We can see that innovation index was around, India was in the 81st rank in the year 2015-16. Okay, 46th rank in the year 2021, and India is at the 35th rank by the end of this year 22. So every year the number of inventions are growing. Definitely earlier also many people had high ideas, but the literacy of IP was not there with the people. Okay, so some statistics, this is taken from Vibo website only. You can see year wise, last almost 1 decade, you can see with respect to resident Indian applications. In the year 2012, around 9,500 applications were filed, but in the year 2021, around 26,000 applications, IP patent applications, are filed by Indian nationals. Okay, there is an increase by 2.5 times. If you come to the second column, second table, that is with respect to grant of patents. In the year 12, it was around 700, very much less, okay, less than 1,000. Okay, but in the year 2021, around 6,384 patents were granted in India, almost 7 to 8 times higher. So year by year, the innovation index of the Indians is improving, right? So by more and more applying patents, converting them into products, we can become more self-reliant. We need not buy anything from other countries. Whatever are our problems, so our youngsters will get ideas, they will convert it into patent, they will do their own startup, and they will start selling their products, so that our standard of living will be higher and we will be competitive in the global market, right? So what can be patented? So there are 4 important criteria. So you have an idea, with the help of some drawings, abstract, etc., you start drafting it. So there should be 4 conditions satisfied, okay, in order to claim a patent. Okay, so according to section 2J of the Indian Patent Act 1970, an invention means a new product, or it might be process also, in having an inventive step, and it should be capable of industrial application. Okay, so such invention which has some inventive step and which is capable of industrial application can be protected by the patent laws. So this inventive step or idea should satisfy 4 conditions. First is patentable subject matter. There are certain subject matters in which you cannot apply for a patent. Okay, in the next slide we will discuss. Okay, it is described in the Patent Acts, right? So next, the second criteria is the novelty. So the idea should be very new. It should not be available in the public domain at all. Okay, when the controller, when you apply for a patent, it goes to an examiner. We call them as controllers. So when he does the prior art search, already published data, it may be with respect to journals, articles, or patents, it should not be available anywhere. It should be totally new and it should be your own idea. The third should be non-obviousness. So you take 2-3 patents of similar type, try to combine them and put it into a form and apply for a patent. So any skilled person in that particular field, say example, I'm working in the field of biodiesel, example, okay, and combustion, I'll take 2-3 different ideas, try to mix them up, and I'll just try to publish a patent. It will not be possible, because any person who is already skilled in that, he will be knowing that it will be an obvious process. Okay, so it should be non-obvious. And the fourth, once all these 3 criteria are satisfied, whatever your idea is there, it should be having some industrial applications. That is, you should be able to convert it into a product and it should be useful to the society. These are the 4 criteria that should be satisfied in order for a grant of a patent. Now what we will do is, we will take one by one criteria and we will discuss in detail. Okay, so first is the patentable subject matter. So once we complete the 4 criteria, then we will take a case study and we will try to discuss these matters. Okay, so the first criteria is patentable subject matter. So under this we will study what cannot be patented. So there are certain subjects, So in which if you do some research and find something, you will never be able to patent it. So these subjects are very well defined in the Patent Act 1970. The section 3 and 4 of the Indian Patent Act, if you refer, the detailed description of all these subject matters will be available. The first most thing is discovery of any living thing or non-living substance or objects occurring in nature. So it is just a discovery. You are not inventing anything. It is already available in the nature. Just you are discovering it. Such things cannot be applied for a patent. Okay. The second condition is a substance obtained by a mere admixture of the components. If you mix 2-3 different components and get a new product, okay, by the mixture of 2-3 components, you will not be able to get a patent. In the first step itself, it will be abundant. One example I have taken here. So paracetamol, it is quite commonly used, and past COVID times, it is one of the popular drug. Okay, so it is antipyretic, which can reduce your temperature, that is fever. Okay, that is very well known in the market. And one more drug example, we take brufen, which is analgesic, which reduces the pain. Okay, especially brufen is used to reduce headache. If you mix these two components, you are a pharmaceutical person, you mix these two components in different proportions, and you'll try to release in a new brand name, apply for a patent, it will be rejected straight away in the first step, because the compositions are very well known in the market. They are available in the public domain. Just by the admixture, you cannot be getting a patent. One more example, a soft drink, what we use like Pepsi, Coke, wherein just sugar is a known product and some colorants, aerated water, etc. You mix 2-3 products, convert into a second product, it will not be accepted as a patent. So by substance which is obtained by mere admixture of the components, cannot be patented. Okay. Certain components, like for example, you take any surfactant which is used in chemical industries. So how these surfactants are formed? You will mix 2-3 chemicals, right? So by chemical reaction, a new product will be formed. There will be a lot of chemistry involved in that. In such cases, with the proof of complete reactions occurring, if you can present, then a patent will be granted. Just mere by combining two products, you cannot get a patent. The third criteria is mere arrangement or rearrangement of or duplication of the known devices. Okay, there are certain known devices. If you combine those devices in different form and try to apply for a patent, in the first step itself, it will be rejected. Some examples I've given here: a bucket fitted with a torch for use in rural areas. Where a bucket to carry some water is a very known product. A torch, which gives out light, is a known product. You cannot combine two products into a single one. It is as good as point number 2. Umbrella with a fan, a clock and radio in a single cabinet, etc. Such things cannot be patented. An invention which is in effect, which is known as a traditional knowledge. So traditional knowledge, that it will be documented. Okay. So some plant species, you want to prepare some medicine, it cannot be patented, which is mentioned in the traditional knowledge. If you develop some product out of that traditional knowledge, you will be able to patent it. Next, a mathematical model or a business method or a computer program cannot be patented. So mathematical model or these methods can be IP you can get in the form of a copyright, but not as a patent. Moving to the next. So an invention whose use could be contrary to the public or which affects the morality and which causes a serious harm or prejudice to humans, animal or plant life, you cannot claim as a patent. Even though it is novel, the product developed by you is a novel, okay, you cannot claim a patent. One example I have taken: a new type of gambling machine, a device to destruct the constructed buildings. Okay, so like that, if it is harmful to the society, in the very first step, the product will be abandoned. Inventions related to atomic energy are completely governed by the central government, so you cannot do any experimentations and you cannot apply for any patenting. Next, a method of agriculture or horticulture. Okay, they cannot be patented because agriculture is one of the basic need for the food of the human beings. If you find some new method, it will be open to the public domain. You cannot claim your right there. For example, you find some new method of cultivation of algae. It is a multi-purpose plant required now. So producing new form of a plant, preparation of a known improved quality of soil, If you do some research on that, you cannot patent it. You can publish a journal and keep it open to the society for general use. Next, any process for the medicinal, surgical, curative, which gives cure, diagnostic. Okay, so any machines for diagnosis of certain diseases, therapeutic therapies, etc. They cannot be patented as they are required for the treatment of human beings and animals. You can publish a journal and it will be open to the public domain. Anybody can copy it and create more number of devices or medicines for the public cure. Plants and animals, any living organisms except microorganisms. For microorganisms, there are a different set of procedures where you have to do some deposition with the international national agencies. You should get a certificate, then you can apply for a patent. Microorganisms, except for microorganisms, you cannot claim patent for any plants and animal species. Seeds and biological process for production of plants and animals. In that process, you cannot claim any patent. So these are some of the areas which are listed in section 3 and 4 of the IPA 1970. So that if your invention is not related to these points, then it will move to the step 2, that is novelty. Now, before moving ahead, one small clarification we will see here. So any discovery you cannot patent it, any invention you can definitely patent it. So discovery just adds to the human knowledge which is already available in the nature, okay, but it will not be seen by the people earlier. Okay, it will be available in the nature, okay, but it will not be realized by the people. That is called as discovery. Any discovery you will not be able to apply for a patent. Invention adds to the human knowledge, something new. It is not already existing. It is your own idea which results in a new product or process which is useful for industrial applications. Only such things you can patent it, right? So one example we will take here, Archimedes principle, very popularly known principle, okay, which describes buoyancy effect. Okay, you cannot apply any patent such based on such principles. They are all discoveries. Buoyancy effect is already there in the nature. Okay, some scientist has found out it. He has identified and made it aware to the public. But if you design something based on the Archimedes principle, an apparatus or method for the human good, then you can apply for a patent. A superconducting phenomena, okay, which offers the least path of resistance for the flow of electrons. Say, for example, based on the phenomena, you cannot obtain any IP. But if you design an apparatus or method applying that phenomena, which will be converted to a product, then definitely you will be able to patent it. So the first step of the patenting, okay, that is subject matter, we have completed. We will come to the second step, novelty. So what do you mean by novelty? So something new should be there in your finding. 1 second, please. Yes. So these days, Q1, Q2 journals itself, they expect 100% novelty in your work, right? So patent, definitely there should be 100% novelty, whatever you have claimed, okay, and it should be 100% new. It should not be available in the public domain. So novelty requirement basically states that the invention should never have been obtained, published in the public domain. It must be new with no same or similar prior arts. The first step that will be done is subject matter. Subject matter, once it clears, so literature survey, prior art in simple words is nothing but literature survey will be done. So nowhere this idea should be presented. Okay, so under section 2 bar I of the Patent Act, novelty is defined as any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. So if you file on 1st of January 2023, before that your idea should not be available in the public domain. The subject matter should not have been available in the public domain. So whatever idea you are presenting, that should be not available in the public domain. This is the second. The third is the non-obviousness. So as I told you, you take 2-3 different products in the same field, try to mix them, come up with a new product, try to patent it. It is not possible, right? With one simple example we will discuss. So what do you mean by non-obviousness? This means that the invention must not be obvious to a person who is skilled in the same field, okay, as the invention relates to. See, I am from mechanical background. Certain processes are familiar to me in mechanical. Okay, something if you try to mix 2, 3 and show me, I may be astonished. I may feel that it is something new. Okay, for example, pharma example, we take pharmaceutical, right? So it will go to a controller who is expert in that area. If you try to mix 2, 3 different combinations and try to present it as a patent, he may feel it as an obvious thing and he may reject it. So a person who is skilled in the same field should not feel that the invention is very obvious, it is not, it is already existing in the nature. So non-obvious is defined in patent section 2JA of the Patent Act. It is defined as the feature of an invention that involves technical advance. It should be technical advance as compared to the existing knowledge. It should be technically advanced as compared to the existing knowledge, and it should have some economic significance. Okay. So it should not obvious to a person who is skilled in the art. So we will take one example. Road salt is most popular in some of the countries where there is lot of snowfall. Okay, road salt in the form of large flakes, if it is put, it will be able to melt the snow and it will keep the road very clear. Okay, so here we can use two different mixtures. One is sodium chloride and second is the potassium chloride. So any chemical person would be very obvious that you can interchange these two chemicals. Okay, in place of sodium chloride, you can use potassium chloride also for certain chemical reactions. So there is a known phenomena in which sodium chloride is already frequently used. If you try to apply for a patent by changing the composition, that is by using potassium chloride, it might be new to a non-skilled person in that field. You are a computer science engineer, you might not be aware of that. But if you go for any chemical or mechanical engineer, they will be having some small knowledge. They will feel that what is new in this? Already some salt is used. Instead, an interchangeable salt is put in that place and they have applied for a patent. So it is obvious that certain chloride based salts in the form of flakes, if you put, they will be able to melt the fog and it is already patented matter. Okay, so like that, it should not be obvious to the person who is skilled. This is the third requirement. And the fourth requirement is capable of industrial application. So what do you mean by this? So the invention should be made useful to the society. How it can be made useful? It should be having certain industrial application. You should be able to produce number of products and you should be able to sell to people so that their life becomes more easier. So this essentially means that invention cannot exist in abstract. It must be capable of being applied in any industry, particularly utility-based industry. The proper definition of this industrial application is available in section 2AC of the Patent Act. The invention is capable of being made or used in an industry. So these are the four criteria an idea has to pass through in order to get patented. Now, what we will do is, here subject matter is the first important thing. So there are certain subjects wherein you cannot apply for a patent, that we have already discussed. Once the idea you have applied has cleared the subject matter issue, it will go to novelty and non-obviousness analysis. We will take one simple example. So this is a bottle, okay, which is used for storing water and drinking water, maybe during traveling, so that it will be having certain features which makes it very easy to use for the traveler. So a complete specification is given by the original inventor to the invention, or I mean patent office. So he claims that this is a new product, a water bottle cap, right? So it has three important regions. One is a base, so base of the cap, which will be threaded. Okay, so it is an opening having a locking mechanism. Locking mechanism is the thread, so that if you strongly thread it, water will not leak. So this is the first invention. The second is a water outlet pipe adapted to be received inside the opening. So there is a opening to drink water and there will be a pipe, okay, which will be inside the bottle. And the third is a closure member, in order to avoid some dirt being falling, because you will be holding it in your hand in heavy traffic. So to avoid that, a cap. Okay, so it is an highly engaged to set base. It is engaged to the base. This is the base of the cap, so it is hinged to the base. Okay, it has two important positions. One is close. When you close it, the cap will close the water opening so that it will not leak and it will prevent the dust. When you want to use it, that is for drinking water, you will just open the cap and start drinking water. So inventor has filed a patent with these three things. Now, when it goes to the patent office, the first thing that will be verified is patent subject matter. It is not any living thing. It is not related to any nuclear, okay, or it is not related to any harmful to the society, so that it can be patented. It is just a product, okay, which is made of certain polymer based material, right? So first step will not be a problem. The second step will be the novelty check. So what does the examiner do? He will start checking in the database with respect to similar patents. And say, for example, he has found two different articles which are related to the same invention. In the first article, it discloses a water bottle cap having a base. Please try to understand. So in the first invention, okay, in the first invention, a water bottle cap is there with certain base. Okay. Further, a straw adopted to received inside the opening. So again, there is a straw here, okay, which helps in drinking the water. The straw has a direct closure. There might be a small cap for the straw in order to avoid water leaking. This is the first prior art available. It may be in a journal or a patent for the controller. The second prior art, okay, the second prior art when you take, so it discloses a water bottle cap with a base. So this is the second prior art. So it discloses a water bottle cap with a base. So this is the base. Okay. Further, a closure member is hinged attached to the base. That is, this closure member with the help of a hinge is already there. So, and the closure members moves between two positions, open and close. So these two are the prior arts available in the literature. So first states that there is a closure member base and there is a pipe with a small cap. And in the second, there is no pipe, there is a base and a closure member. Okay. So how the examiner will analyze this case? Okay. So first he will go to the prior art one. So novelty assessment. First we will take how the novelty assessment will be done. In the first, okay, there is a base which is common to our invention. So I'll take it as yes. There is a water outlet because pipe was dipped. I will take it as yes. But there is no closure member defined here. Correct? So cap is not defined. Only some closing mechanism is there here. So closure member is not there. So your idea with respect to prior art 1 is novel. It is not copied from prior art 1. Then when you go to the prior art 2 here, base is there as usual. So yes. Then water outlet. In the prior art 2, there is no question of any description of water outlet mechanism or a straw here. It is not described. Closure member, cap, it is there in the prior art 2. So point 2 is missing in the prior art 2. So it shows that you cannot, you have not copied anything straight away from the prior art 1 or prior art 2. So that the patent examiner or controller comes to a conclusion that your idea is novel. Already in the disclosed literature, then idea similar or same to your idea is not existing. So your invention has crossed step 1, subject matter, no issues. Step 2, novelty assessment, no issues. Next, what will be the third step? It is non-obvious assessment. Okay. So any person who is skilled in the manufacturing industry or may not be in manufacturing, any general user, if you demonstrate this idea, obviously you can feel that it is very obvious. In the market, many such models are available. If you combine prior art 1 and prior art 2, there are 3 claims made by you. That is, one is base, water outlet and closure member are designed as a new method. Okay, if you combine prior art 1 and prior art 2, obviously your idea will be arrived at. Am I right? So prior art 1 discloses a base and a water outlet. Prior art 2 discloses base and closure member. If you combine these two, base, outlet and closure member will be definitely available, so that it is very obvious. So straight away in the third step, your application gets failed. It is combination of two different prior arts. Okay, you should be able to strongly prove that if you combine these two, you cannot get your product through an hearing or a reply to the examination report. Okay, so combination of 2, 3 should not arrive at your idea, right? So I think it is clear with the help of this example. Now we will take up some examples of patents which are applied in the past. The first Indian patent granted was in a efficient punka pulling machine. This was in the year 1856. Okay, almost 2.5 decades, I mean 2.5 centuries ago, a civil engineer called as George Alfred Depening. Okay, so earlier days, what used to happen for blowing of air, you can see here somebody is having food in a restaurant. So there is a servant, punka puller. He used to pull the rope manually so that this whatever flap is there, it used to move left and right. The air was blown. Okay, so this civil engineer made an idea and he developed a mechanism. Okay, so that this when you start rotating this wheel, automatically the fan should be turning. He demonstrated some certain mechanism. In 1856, he obtained the very first patent. This is called as the first Indian patent. Some more examples which are very simple, you can see, which we use in our day-to-day life. A paper jump clip, what we use in our office. Okay, so this was first patented in 1927, right, by George Griffiths from America, right? And video game, right, in the year 1973. Okay, television gaming and training operators was patented. And in 1849, the safety pin what we use was patented by a US person. Then the Barbie doll, most popular for kids. Okay, earlier, the originally it was patented in 1961, used as a storage device for its aesthetic. Next, Rubrik's cube, one of the popular device these days to check the IQ. Okay, it was patented in the name Spatial Logical Toy in the year 1983 by an Hungarian inventor. Then the tricycle. Okay, it is called as velocipedis in the olden days. In the year 1875, it was patented. We know very well rocking horse. Okay, it was patented in the year 1902. Okay, so as per that patent, they claimed that by little amount of labor, that is work, you can move forward in this horse. Okay, these are some of the old patents. Some of the notable inventions in the which are patented. 3D printer. This is one of the popularly used device now. There is lot of scientific improvements. Okay, it is called a stereolithography. This was originally patented in 1986, almost 40 years back, say. Okay, so here the table, whatever the there it used to move, and the nozzle was fixed. Some resin was splitted here based on the computer control system. So any shape product can be obtained. UV light was used for drying. 3D printer. This is wonderful invention. Maglev train, magnetic leviation train, where two sets of electromagnetic will be there. One electromagnet keeps the train almost 4 inches away from at a higher height from the train. Other helps in propelling the train. So this was patented in 1967, right? Drone, what we see, it was patented in 1962. Very first time it was given a demo. Next, GPS system. It was done by Naval Research Laboratory of US for tracking of the satellites. Bluetooth. It was originally patented in 1994 in the name of peer-to-peer information exchange for mobile communication devices. Next, solar panel. It was patented in 1839, very early days. Okay, so there were certain materials found when the sunlight falls on it, some electric charge was developed. Next, self-driving car. Multiple patents have been granted in this. In that, the most successful implemented patent is by Wislab in 2013. Okay, they had filed a patent where over 5,000 kilometers a vehicle was demonstrated autonomously. It was driving through two-way streets, crosswalks, traffic lights, etc. Okay, these are some of the inventions, okay, which are useful to the humankind. Now, we have learned what is a patent, what are the conditions that should be satisfied in order to obtain a patent. Now, we will come to the next. You have an idea, you feel that all 4 conditions are satisfied, you have drafted, you have given a description with suitable sketches. Now, how to register it is the next question. You can do it through patent attorney, or if you are an Indian national, you can directly file in the IP website with the suitable documents. You can directly apply, or through patent attorney you can do it. So filing an application for patent includes details such as your name, address, email, contact number, everything you have to give. There are certain forms available in the patent website. Form 1, okay, request for grant. Form 2, provisional complete specification of your patent. Form 3, statement of undertaking of the patent loss. And Form 5, declaration of inventorship. These 4 forms you can fill along with your abstract and the complete invention. You can upload to the IP website. Once it is done, okay, the second step is your idea will be published in the similar to your journal publication. In the patent journal, your idea will be published. Okay, so usually it will take 18 months. After 18 months, it will be coming to the public domain. If you want it to get published at a faster rate, then you can apply for early publication. You can, after filing your patent with some small requisition fees, Form 9, if you file, within 30 days, it will be made available in the public domain. Once it is available, published, then you have to apply for examination, right? So within 48 months after filing, you can apply for examination. Without applying for examination, your patent will publish and it will stop at that stage. After 48 months, it will be abandoned and made public. Okay, so you have to apply for examination. That is, there is a form available called as Form 18 with requisite fees. If you upload Form 18 in the IP website, so your patent will be forwarded to one of the controller. What this controller will do, he will study with respect to all these four processes. First, he will check for the patent subject matter. If it is satisfying, then he will go for the literature survey, that is prior art search. Okay, for novelty, then he will check the non-obviousness. Then finally, in the fourth stage, whether your idea is applicable to the industry or not, he will check, and he will generate a examination report. It is called as first examination report. And this first examination report will be sent to you through mail usually. Okay, once it is received by you, there will be a time of 6 months for the reply. There will be some objections made. Okay, so if you can justify through proper reply within 6 months, then if the controller is happy with the response, he will directly give it a grant. Or if there are some more objections left out, there is no clarity, then he may call for a hearing. He will send a letter to you with a date and time fixed, so that you can go there physically or online mode. These days online also it is permitted, so that you can demonstrate your idea. Whatever left out objections are there, you can clear it. If he is happy with your explanation, he may give a grant, or he or she may refuse it. So this is the entire process, right? There are some timelines, usually 18 months for publication. If you file for an early request, it will be published before just within 1 month. Then usually 6 to 8 months, okay, you can get the examination response, I mean reply. Then within 6 months, you should reply for the examination report. If you don't reply, keep quiet for 6 months, directly it will be abandoned. Under extreme situations, you can take an extension of 3 months here. So by the end of 6 months, you are not able to reply for the objections, you can pay some nominal fees and take a 3 months extension there. Within that period, you have to reply for the objections. Okay, after taking extension within 3 months, if you don't give any response, directly the patent will be refused or abandoned. This is the registration process. Now, how to know about the registration fees? For startups, the fees is different. Okay, for educational institutions, industries, it is different. For individual person, it is different. For online filing, the same fee structure is different. For offline, it is different. So I have given a link here. Later, this presentation will be shared to you by IoT. Okay. Very first document is the schedule fees. So in that, you have to select which category you are following, whether you are an Indian or an international person, I mean PCT person, or you are an startup or an individual person or an establishment. In that category, you can check for fees, and all the forms will be available for you. As I told you, you have to go with Form 1, Form 2, Form 3, and Form 5. You have to first fill, upload along with your idea for initial filing. So all these templates will be available in the website. Okay, so next, you have an idea, you have documented everything, you have written. How to check whether it is already available in the public domain or not? You can use some of the websites like WIPO, okay, patent search services by Government of India, or Google patent search. Okay, Skyfinder Scholar, there is a website, patent offices, or British Library. Okay, in multiple search domains, you can search your patent with the help of keywords. And there are certain softwares available. If you go to any attorney or an IPFC, intellectual property facilitation or support centers, okay, once the keywords or your title is given, the similar inventions which are registered in the past along with journals will be given to you. You can study and you can compare with your idea whether it is novel or not before applying. Okay, so patent flow I have explained. I'll take 2-3 minutes on this chart to make you understand what actually will be the exact process. So you have filed your patent application. Either you can do it with the complete specification or a provisional specification. You have an idea, you start experimenting with it, develop a product. Once you have start doing the work with some provisional specification, you can directly file a patent, because you can reserve your right at a earlier rate. Okay, so every day is a delay here. Somebody else may get the same idea and they may apply before you. Okay, with provisional or half data, whatever is available, you can apply the patent, and there will be a time of 12 months, 1 year, for giving the complete specification. Once, if you give the complete specification, after 18 months of waiting period, your patent will be published. Or you can file for a Form 9, that is request for early publication. So within 1 month, it will be published. Once it is published, okay, you will have a time span of 48 months for applying for the examination. On the day of publishing itself, if you apply for the examination, immediately it will move to the next step. Okay, now I have applied Form 9, so that within 1 month my patent got published. So I have applied Form 18 for examination. So within 6 to 8 months, usually examination report, usually it is called as FER, first examination report, will be issued. Under extreme conditions, if you are a startup, okay, if you are a startup, there is an option for expedited examination, because you have to start making your product and selling for the purpose of your startup survival. Okay, if you have applied under ISA or IPEA category, okay, international patent, with India as one of the searching authority, international searching authority, or international preliminary examination of authority as India, if you select. Okay, and if you are a startup, then within 30 days or 45 days, your patent will be examined and the examination report will be given. Otherwise, if you are not a startup, if you are an establishment, or if you are an individual, usually it will take 6 months, not more than 6 months, for FER generation. Okay, so once FER is generated, you will have a time span of 6 months to reply for that, and 3 additional months on request. So within 9 months, you have to reply for the objections. If all the objections are cleared, then you may get your patent granted. If any of the objections are left out, it might be abandoned. In some cases, if the answer to the FER is not very clear to the examiner, he may ask you to appear for a hearing. Okay, if you have directly filed, you can directly go and answer. If you have filed through an attorney, you can go along with your attorney and you can face the controller. So this is the entire patent flow. Okay, so I wanted to show one example. I think we are running out of time. I'll just skip this. This is one of our patent which got recently granted. In the last March, it is granted. What all the timelines and what all the phases it has taken, with some examples I had put here. Okay, it will take another 15-20 minutes extra. We will skip this. Okay, so we have discussed in detail about the patent. We will move to the next important one, designs. Okay, why I am specifyingly taking this is easily in your idea, just without developing any product, with the help of 2D or 3D drawings. If it is new, you can obtain a design patent. Once if the design is patented, then you can further improvise it and convert it into a patent. So design means the feature or shape, configuration, pattern, composition of lines or colors, which is generated either by manually or mechanically. Okay, when it is finished, it should look like an article, okay, which is something new. In such cases, you can apply design patent. One of the design application I was going through recently, a solar panel, okay, which is made compact with the help of some new technologies, with the 3D drawing, was patented. No question of any demonstration, no question of product being developed. Okay, these industrial designs are unique combination of invention, creativity, and design. Okay, so recently I have filed one design application, which is just a light emitting 3D printed cabinet. Okay, a small light, if you give, it gets 1,000 times illuminated and it gives a dark one. The glasses are arranged in that fashion. There is no much complicated technology in that, so it looks something new. Okay, such things can be applied, and they are very fast in processing also. Why should you register such designs? I was just telling, some light emitting 3D printed cabinet. I had an idea, I have produced it as a product. So if I want others from being stopped from making it as a product, I have to register it similar to the patent, so that I'll get the complete license. Only I can produce the similar product in my name and I can sell it. So there will be good commercial value and marketability for the product also. What cannot be registered? If your idea is not new, I have published one design, as I told you, cabinet light emitting. It is already available, almost same shape. It will be definitely rejected. It is not significantly distinguishable. As I was telling you, solar panel design with 3D drawings it was given. If it is not much different from the existing one, straight away it will be rejected. Some subject matters which are scandalous or options which is harmful to the society. Okay, for example, I get a new idea, okay, new shape of producing an atom bomb. Such things will be definitely rejected because they are harmful to the society. And if you have any symbols or designs on that which are related to buildings, stamps, emblems, which will not disrespect our nation, if there is anything like that, then it will be rejected. Otherwise, usually design patents are easy to get. Some as just one example, interesting example I want to show you. So this was earlier Samsung phones before 2007, which was keypad model. In 2007, Apple released a very beautiful model, so it became a very popular phone. Okay, it was called as iPhone. After a few years, Samsung also released a similar project. Definitely, there are some design changes so that copyright infringement is not, I mean, patent infringement is not done. So this is how products are developed. So whatever this is, there is a patented one, this design. Similarly, tab, earlier it was a gaming tab design developed by Samsung. Once iPad 2 was released in 2011, later on it was much more modified based on the design. Like this, if you have any ideas, this can be filed. Registration process for our design applications. So along with the drawings and necessary giving suitable title for the drawing and some specifications, whatever applicable and industrial applicability you can define. And with 3 copies, you can directly file online and you can send it through post. Any shortcomings in the application or any objections is filed by the public, it will be communicated through you, usually through mail or post. And if you can resolve your objections directly, it will be granted. Usually 8 to 10 months is the process for registration of a design. So this is the flow chart which shows what are all the steps in. Sorry. Okay, first you will file the application. Number and date of the application will be immediately given. You will send the documents through post. It will go for the examination. If there is no objections, okay, if your design seems to be novel, okay, directly it will be accepted. If there are any objections, already nearly existing designs are there, or some documents you have not uploaded properly, in such cases, okay, there will be a report sent to you by the controller through mail, either you or your attorney. If you are able to clarify those objections, then it will be accepted. Or if there is any no question of any clarification, proper clarification given by you, it will be directly abandoned. And in some cases, if the clarification is not clear, the controller may call for hearing also. So once it is rejected, there is a provision here, because it like patent, you cannot completely decide everything on this. You feel that your idea is something definitely new, but the controller has rejected. In that cases, you may go for appeal to High Court. If you can prove that it is not available in the literature, and if the available literature is not 100% same as yours, then there will be a chances of acceptance. This is the flow chart of design application, okay, up to acceptance stage. Then the next, copyright. Usually whatever computer programs, algorithms, they are developed by the CS professionals, you can easily obtain copyright within 2 to 3 months in an easier way here. So copyright is the exclusive right given by law for a specific time period of say 60 years currently in India now, for an author, composer, etc., to print, publish, or sell your idea. Okay. Why should you apply for a copyright? You have certain idea, a book written in your own manner, which is very much useful for the student community. If you don't apply for a copyright, if you don't, then anybody can copy it. Anybody can take multiple photocopies and sell it. Okay. So what are the coverage areas of copyrights? Any literary work related to the literature, dramatic and musical works, computer programs, softwares, artistic works, lyrics, cinematographic films, etc. can be applied as a copyright. So what cannot be registered as copyright? Any ideas you have, any methods you define, it cannot be copyrighted. Commonly known information in the society. For example, I apply for a copyright with the plant species, how they grow, in which seasons they grow, how much yield they give, how to improve the yield, etc. It is not a copyright, very known thing. Choreographic works cannot be copyrighted. Any names, titles, logos, etc. Any articles of fashion like clothing, etc. you cannot copyright. Okay, so why should you apply for a copyright? To obtain your own economic benefits. Nobody can copy your work as it is. Okay, so it entitles right holders to claim any royalties out of it, enables copyright holders to claim compensation or damage in case of infringement. Say, for example, there is some music line. There is a popular movie called as Kantara. Okay, there was a big copyright infringement case, which they were not able to prove. It was already published music being copied by the director. So if there is anybody wants to copy your popular idea, they cannot do it if you have already copyrighted it. Registration process is simple. Application, okay, you have to go through the rules. Certain forms are available. Okay, separate application for each work should be applied. Each application to be accompanied by the requisite fees also. Okay, the application should be signed by the applicant or the attorney, in whose favor a power of attorney will be given. Okay, and accepted by the advocate, right? So the last type is the trademark. A trademark is a mark, device, a brand, heading, or a label. Okay, it may be a signature, word, letter, etc., which is registered by you for your product. You have a product, you want to open your startup, you will just make a logo out of it to make the society become aware about your startup. Then it is called as a trademark. Okay. So it helps in distinguishing the goods that is produced by you from other goods which are available similarly in nature. What all can be trademarked? First one is certain words which are written in certain fashion. It may be surnames, names, forenames, geographical names, etc. Like any car company, Maruti, Suzuki, Toyota, Nike shoes. They are written in some combination of letters. That is a trademark. Any letters are numericals in a certain order. Any devices, drawings, symbols. Nike has a very famous symbol, tick mark, that nobody can copy it because it is a trademark one. Combination of any of these, okay, colored marks which are which look different. Okay, any three-dimensional signs. One is Jaguar, you know, there is a flying lady, a three-dimensional sign for their company. Nobody can copy it. It is a trademark one. Audible signs, some signs like musical notes or symbols which are in the form of an audio. Okay, cry of an animal is an example. You can trademark it. Then olfactory marks like smell. You have a writing pad or a sheet. It has a very good smell. People start buying it more. When they start using it, they feel very comfortable. Nobody else can copy it. So these are some of the trademarks. So what cannot be registered as a trademark? Marks which are not unique or distinctive, you cannot, which is already existing by some other company have applied, you cannot. Some adjectives, some word is there, you want to take some adjective and do it, it is not possible. Any name of a person or place, I cannot trademark Bangalore. Okay, I cannot trademark any person name. Any religious names, like in which is related to religion. Okay, and some emblems which are of national importance, etc. There is a list available in the Names Act 1950. They cannot be trademarked. Common shapes are which are against the national interest, okay, or public morality. Such things cannot be trademarked. No, you have a brand, you want to take a trademark. How do I come to know whether it is eligible for a trademark or not? So same as patent search, you can make a trademark search. If it satisfies all these conditions, definitely it will be given as a trademark. So why you have to apply for a trademark? It may be a symbol or a brand name. It gives you some public figure. Okay, it distinguishes your good from other goods. Okay, it facilitates establishment of your branding, right? So Toyota is a brand today. Many people don't want to divert from it, right? Like that. Enhances the market value of an enterprise. Colgate paste. So nowadays, some families are there which they don't want to buy any other paste. Whatever you do with that product, they buy that product only. Colgate is a trademark one. I cannot start my own enterprise in the name of Colgate, and I cannot produce any product there. Okay. So these are some of the examples of trademarks, symbols, etc. Counterfeits will be definitely there. If you can prove that your trademark is copied in civil courts, definitely infringement penalties will be there. Okay, some of them I took as an example. Channel, okay, it is very popular company which makes wallets. People are copying with the change in name of the country. If you can find who is producing it, definitely they can be infringed at all. Some watches like Rolex, same designs are copied by other people. So registration mark, first you can contact any attorney. He will help you in prior art search, where whether similar trademark is already there or not. Trademark filing can be done in IP website similar to patent. It will go for an examination. If there are any objections, it will be sent through post or sometimes mail. Within period of 1 month, you should resolve your objections. You should give a response. Once this examination is cleared, it will go for advertisement of application. A mandatory period of 120 days locking period will be there. So one point I missed, copyright, if you apply, once all these formalities are completed, 30 days it will be made open to the public domain for any objections. Similarly, trademark, 120 days it will be open to the public domain. If anybody has objections, they will apply. If there is any objections or opposition, okay, then both the parties will be called and you have to prove yourself that your trademark is novel. Our opposite party has to prove that his symbol is been copied or his brand name is copied. If they are able to prove, then it will be abandoned. Otherwise, it will be granted. Initially, it will be granted for a period of 10 years. Then upon renewal, another 10 years, you can take it. The last one, just I'll take 2 more minutes. Geographical indications. It is a sign used on goods that have a specific geographical or origin. Okay, so it will have certain special qualities. For example, Kashmir apple is famous because of that soil and climatic conditions. The apple has a very good taste there. So the same plant, if you bring and grow it in Bangalore, it cannot give you the same taste. Okay. So some of the products, because of their origin, they become famous, like Mysore sandal, etc. So when a community of people or a community of industries apply for a GI, other people cannot copy and sell in the name of that product. For example, nobody can put a tag unless otherwise the apple is produced in Kashmir. Okay, the tag should not be put. Okay. What are benefits of this GI? You will get legal protection. Okay, somebody cannot grow in some other area and claim that it is an Kashmir apple. It prevents unauthorized use of a registered GI. Okay, it promotes economic prosperity of goods. It boosts the export. In foreign, Kashmir apple has a very good value. Okay, somebody else from some other region, they grow and put the sticker of a Kashmir apple and sell. What happens tomorrow? The quality of apple goes down. People stop liking it. So your branding of our product becomes very lower. The local apple growers in Kashmir will be badly affected because exports will be stopped. Correct? It can serve as a source identifier, a branding. Some loyal customers, consumers will be there. They will be ever buying your product because of the GI tag. Okay. And in some cases, say for example, today we go to the market, Kashmir apples are highly priced compared to the local grown ones because of their taste. Some people will be willing to buy at a higher price. Okay. One more example, geographic location is an important component of wine pricing. Certain areas where wine is produced, it is very much costlier compared to other areas. Who can apply? Here, individual cannot apply GI because it is not his property. It is because of the origin. A group of association of people or producers or organizations or authorities which are established under the law, they can apply with a public interest, not their personal interest, with a public interest. The application must represent the interest of the producers. Okay. What is the impact? It encourages rural development. Today, many families in Kashmir are dependent on farming, okay, of apples. Facilitate market access. It saves local natural resources. Okay, it plays an important role in the preservation of our cultural identity. Some of the examples: Odisha Rasgulla, it is a GI. Nagpur orange, okay, Madurai Malli, Madhya Pradesh hen, Tirupati laddu, Malgova mango, Darjeeling tea, famous product, Mysore sandal, Erode turmeric. These are all GIs which are applied by a group of people. So they will sell with their tag in abroad also. So just one example, I took some of the famous products which are applied under GI. Right. So these are from 19 to 20, just before pandemic. I just took it from the government website. What are the recent GIs that are sanctioned? Okay. So these are some of the agricultural, food stuff, handcrafts, etc., which are tagged. Right. So finally, we will summarize like this. We have discussed about mainly patents, trademarks, copyrights, and designs. Patents are given for innovations or inventions which has to satisfy 4 conditions. Certain subject matters are there. In that subject, your invention should not fall. It should be something new, novel. It should have some industrial applicability, and it should be non-obvious. Okay. So usually the grant will be given for 20 years from filing date, not from your grant date. Okay, I have filed in 2020 beginning, just before pandemic. Okay, recently I got the grant, but from 2020 your idea is patented. Okay, based on the first 2 years it will be free. After third year onwards you have to pay some renewal fees. Okay, up to 20 years it will be your property. After 20 years it will be kept open for the public domain. Next, trademarks. Okay, for distinctiveness of the marks or symbols, it will be given for 10 years. Every 10 years you can keep on renewing it until your brand or your enterprise is existing. Copyrights are usually for artistic, musical, literary works. Usually the time span that will be given for 60 years or until the death of the original author. And designs will be given for 10 years. For novel individual character design, IP will be sanctioned for 10 years, and upon request and paying some nominal fees, another 5 years extension we can take, 15 years. After that it will be given to the public domain. So with this, some I have completed my presentation.
The session is open for discussion now. You can unmute and interact with the resource person, or you can post your questions in the chat box also. Thank you,
You
sir.
can
Thank
post
you all.
questions in chat box also, and I have given my mail ID to the IoT Academy. Any questions you can send through mail also. I will be able to answer. I am working on these things from last 4 to 5 years. I am also an innovation ambassador. Okay. Okay,
Dear
if there are no
participants, you
questions,
have
it can be
moved.
sent through mail. So through IoT Academy, I can answer them. So all the questions, madam, whatever you get, you can just consolidate and give it to me. Also, I will share one material to you. This is not prepared by me, but it is released by Government of India only to facilitate inventors to clear their doubts. Okay, some frequently asked questions, over 100 questions, it has been published, wherein complete patent related details you will be getting. I'll share it to IoT Academy. So you can in turn share it to the participants, so that any questions you have with respect to these processes, it will be a ready reckoner. Okay. So if there are no questions, thank you all. I hope all of you are happy with the presentation. You learned something new.
Yes, sir.
Okay.
It was a yes, sir. On behalf of IoT Academy, we thank Dr. Sunil sir for the informative session, for the informative, detailed, enriching, and enlightening session, sir. And we thank you very much for the amazing presentation. And we thank you for enhancing our knowledge with the commendable presentation, sir. We thank you very much for your efforts, sir.
Thank you. Thank you all.
Thank you, sir. I thank
Thanks.
all the participants for joining the session today. Kindly submit the feedback form using the link that will be posted in the chat box. Thank you all. Have a great day. Thank you, sir. We thank you very much for your efforts. It was an amazing session, sir.
Thank you, madam. Thank you.
Please submit the feedback form using the link that has been posted in the chat box. Thank you all. Have a great day.